them, put them on vibrate so as not to interrupt today's proceedings. The board would appreciate it. The procedure will be to introduce the case record as the Codes Department has it on the wall here by means of a PowerPoint presentation. We'll present any site plans, photographs, and maps of the properties involved in today's cases. We'll also present any letters that we've received in support or opposition to a case, as well as any correspondence from other government agencies. At the conclusion of our presentation, the applicant will come first to the table here. I will have you chairs here shortly. I apologize for that. Along with any persons in support. If there's opposition present after the appellant speaks, the opposition will have a chance to address the board. In the board's rules, in cases without opposition, the applicants have 10 minutes to present their case to the board. In a contested case, that is a case with opposition, each side of a case will have 15 minutes to present their testimony. So applicants in opposition, if you have multiple speakers, you have 15 minutes for all parties speaking. So please divide your time accordingly before coming up and addressing the board. When you do come up, you'll have a microphone stand very similar to mine. Notice the red light along the microphone is lit. There's a button on the table that says speak. When you hit that, the light comes on. When you get done talking, if you would, please turn that light off. All section numbers I refer to today come directly from the Metropolitan Zoning Code, which is Title 17 of the Metro Code of Law, and was adopted by the Metro Council with an effective date on January 1st, 1998, and applies to the entire jurisdiction of the Metro government. I'll introduce and make a part of the record the zoning code, and will dispense from reading individual sections unless the applicant or opposition requests that I read those sections. Thank you. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address the board to come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that it's found if anyone's presented false or misleading testimony to this board that may have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will discuss and then vote on that case. Thank you, sir. The board is vested with the powers to act on these cases before us today as outlined in Section 1740-180 of the Metro Code of Law. The code requires that 4 members of this 7-member board be present to constitute a quorum. Today I have 6 members present. The code also requires that you have 4 affirmative votes to grant your application. So you need 4 of the 6 members present to approve your vote for approval of your case for your case to be granted. In the event that we have a tie vote, today would be a 3-3 vote, your case will stay on our agenda for the next 30 days. Those 6 members are still eligible to participate in the case and can change their vote at the next hearing. The 7th member who is not present today may review the record, watch today's proceedings, and then become eligible to participate in the next meeting. Excuse me. In the event that you do not get 4 affirmative votes at that next meeting, your case is deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, any appellant or aggrieved property owner may appeal this board's decision to Chancery Court in compliance with applicable state regulations. If you're an applicant and your case is granted, it is necessary for you to obtain the permit for which you've applied. It should be noted that you have 2 years from today's date to pick up your permit for the board's approval to remain valid. If you get approved today and you wait 2 years and a day to come get your permit, you have to start over and come back to this board. Mr. Chairman, I submit that all cases were filed in proper order. All appellants were notified by certified mail as required by the code. All affected property owners were notified by first-class mail within 300 feet, and a legal ad was published in the Tennessean. Before I begin, the board allows elected officials to address the board prior to public hearings begin. Are there any elected officials present who wish to address the board? All right, Council Lady Berkeley Allen, please come forward.
Thank you very much. I thought Joey just needed a chance to get some water.
I do, thank you.
I'm Berkeley Allen. I'm councilperson for the 18th District, and I would like to speak in support of two cases that you have before you. Case 21280 is at 511 Chesterfield. That's a 20 townhome development. The applicant has communicated well with me and with the neighborhood. We held a public meeting. As is always the case in my neighborhood, there are concerns about parking issues. Although his property is within the required number of parking spaces, I think it may have one or two extras. So he has complied with the letter of the law and has agreed with my request to provide some on-site lockable covered bike storage to encourage his owners to be bike riders and transit users, which I think may help with the parking situation. So I ask you to take his request into consideration, and I do support that one. The second one I would like to speak in favor of is 21283. I did that backwards. I'm so sorry. What I just said applies to 21283, 24th and Ackland. And I'm now speaking in favor of 21280, which is 511 Chesterfield. That's a 43 single-family home development. This owner also came to me, communicated well with me, held a public hearing that a number of neighbors attended. Those neighbors are pleased that this development is much smaller than previous proposals have been made. His main request is to bring his for a front setback variance on the street side, and we're comfortable with his application. We did talk some about sidewalks related to that and just some possible speed issues on the street. I realize y'all don't have jurisdiction on either of those issues, but if you would join in saying yes, traffic and parking, we would like for you to evaluate this situation and see if any changes need to be made. We'd appreciate I would appreciate your joining the chorus with me on that one. But I am pleased with what they presented and would like to ask you to support 21280, 511 Chesterfield as well. Thank you for allowing me to speak.
Oh, Councilman Allen, before you leave, the meeting for board members, I think, who are new, we had the original proposal for this Chesterfield property that we approved. It was a different proposal, so they have come back with a new and improved, I guess, proposal. The main difference, he said, is just kind of the density is a little bit less. Is that what you said?
Well, what I have been looking at since, for the past number of months, how long? I've been working with these guys for a number of months with 43 single-family homes at 511 Chesterfield. That should be what you have, is that?
Right, that's what we have.
Correct.
And I see the glowing letter of support from my neighborhood association, and it's always good to see my council person here too as well. And it says the Hillsborough West End Neighborhood Association approves and strongly supports the request by the developers. Quite a statement.
How often does that happen? Yes.
I know.
I told them they're heroes. So
great job on that.
Thank you very much.
Thank you.
Thank you. Ladies and members of the board and folks with me, I apologize. It's the first time in 14 years I've come to a meeting without a tie on. So on top of my great voice, which is working today, I just
Should we start over? Do you want to go get a tie?
Well, you're not wearing one, so I thought maybe I wanted to be more like you.
I'm wearing shoes, which is new.
These architects,
but
right?
I usually keep a spare in my office, and I went to get it, and it wasn't there, so I'm sorry. It's not my normal style.
I thought maybe you were the one that hit that lottery for $300.
No, sir, if I had hit the lottery, I would not be standing before you. The board has a consent agenda, and prior to the meeting, a board member, in this case the vice chairman, Mr. Dick King, reviewed the record in the case. And if, in their opinion, the applicant meets the criteria for the application they've requested and they feel testimony would not alter the material facts, they recommend the case to the remainder of the board for approval. I'll enter into the record those cases now, and we'll call out those numbers. If you're here in opposition to a case or would wish to address the board in this case, please raise your hand when I call these numbers, and we'll remove that case from consent and hear it in its regular order. The first case recommended for the consent agenda is case 2012-76. Ms. Donna Taylor, located at 540 Westgate Court, requesting a variance in a side yard setback for an existing carport. Is anyone here in opposition to case 76? Mr. Chairman, seeing none, this case is recommended for consent with the condition that this carport is to remain open. Ms. Taylor, do you agree to that condition? All right. The applicant is agreeable with that. The Vice Chairman recommends that for consent due to the irregular shape of the property. The next case recommended for consent agenda is case 2012-77, Ms. Donna McClure at 929 Morning Road, requesting a variance in the rear setback to install a cover over an existing deck. Is there anyone present in opposition to case 77? Mr. Chairman, seeing none, the exceptional topography on this lot necessitates the need for variance in this request, and Mr. King recommends that case for consent. The next case recommended for consent agenda is case 2012-80, Chesterfield, located at 0 Chesterfield Avenue, requesting a special exception in the setbacks for the front 9 units of the proposed development. See any parties here opposed or would like to address the board on case 80?
I have a question.
Okay.
Back up one. 077. What does that mean, what you just did?
Well, the board has recommended that case for approval on consent agenda. It hasn't.
Well, no.
Yes, sir. No problem. Sorry I missed your hand there. Any other parties on case 80? Case 80, seeing none. This request conforms with the special exception requirements of the zoning code, and Mr. King recommends consent for that case. The next case recommended for consent is case 2012-81, Highland Heights School and Metro Government, owner of the property at 123 Douglas Avenue, requesting a special exception in the RS5 district to construct additions to the Highland Heights School. Is anyone here in opposition to case 81? Okay, Mr. Chairman, seeing none, this case meets all the conditions for special exception under the zoning code, and you recommend that case for consent. Next case recommended for consent, case 2012-82, Benjamin Hornsby, located at 534 Moore Avenue, requesting a variance in the side setbacks and height requirements in R6 UZO to construct a new second floor to an existing detached garage. This subject garage remains now. The roof is gone off of it. The existing walls are remaining. I believe the applicant wishes to utilize those walls. Is there any persons present in opposition to case 82? On Moore Avenue. Mr. Chairman, seeing none, this case is recommended due to the exceptional topography of the lot. And Mr. Chairman, that is the consent agenda as listed by you.
Okay, questions? Got a motion for a second.
Yeah, I'll make a motion for the consent agenda, but I would like to just make a comment from Council Lady Allen's address that we do approve the case 80 and ask that traffic and parking work with the count. The switch? The 82. Okay. Then never mind on the traffic and parking on that one. It applies to one that we'll hear. I was a little bit disturbed by the first case, which I think should be on the consent agenda, but I would like to, as I make a motion to accept the consent agenda, ask that codes send a letter to the home improvement company that was referenced there, just to make sure that they understand that they need to apply for variance and permits. I don't think the homeowner should be penalized, and I think it probably would have been granted had they come here, but I don't like folks that come and ask for forgiveness rather than permission. So I would like for that company to be on notice that they should have done that and to be aware of the rules next time.
Yes, sir. And our department joins you in, especially a licensed contractor is fully knowledgeable that permits are required. They advised the landowner that no permit was such required. She detrimentally relied on that advice. And actually this came up when she came to see us for a permit on her home that she was going to do, and right. We couldn't issue it until this was resolved. So we'll be happy to write them.
Yeah, I would make a motion on that condition that codes write that letter.
Well, Joey, before we do all that, it seems like a lawyer for one of the clients wants to talk about what we just discussed. Is that correct, Mr. Wright?
I was going to raise one matter is announcing the consent.
No, sir. That's true, Don. Excuse me. That's all right.
Okay, we have a motion and a second for approval of the consent agenda. Any further discussion? All in favor of the motion, say aye.
Aye.
Opposed, no.
Okay. You adopt, again, recapping, case 76 approved with the condition that the carport is not to be enclosed. Codes will write a letter to the contractor admonishing them on the need for permits in the future. Case 77 approved. Case 80, 81, 82 are all approved. If you're here for those cases, you are free to go. Again, 76, 77, 80, 81, 82 are approved, and we'll call the first case today, case 2012-78, DY Properties 2 LLC, the appellant and owner of the property at 907 19th Avenue North. The applicant is present. If you'll come forward, sir. Are there any parties opposed to case 78? Present. Mr. Jenkins, you'll have 10 minutes. Let me show the board photographs, explain to them the nature of the request before us, and we'll get underway. Members, Ms. Hughes reminded me I have one letter in opposition to this request that was mailed in. And Ms. Hughes, if you wouldn't mind, provide the applicant a copy of that letter to load it. The next case, subject case, is located on the west margin of 19th Avenue North. This is just west of Dr. D.B. Todd Boulevard and south of Hermosa, north of Herman Street in North Nashville. The subject lot is located in red. This is an aerial photograph of the subject site and site plan submitted by the applicant. The variance request before us involves the perimeter landscaping requirements on both the eastern, I guess this would be northern and southern boundaries along the parking area that you'll see on the street. The plan called for and required a 5-foot width with trees you see marked on there. And the applicant's proposing, this is a view of the subject site looking into the site. These would be those two areas that we were discussing along the parking area. Code's currently still working with the applicant on final, finishes on this subject site. So I don't want you to be concerned about the gravel parking. That'll get taken care of after this appeal on that. This is the adjoining property. I believe you own this property, sir. Yeah. Okay. He owns the subject property adjoining where the portion of that building is. Along that parking lot, there's a retaining wall which you don't pick up right there, and then along the northern boundary in this area, and where the perimeter landscaping is required. I'm going to pull that back to the site plan. At this time, I'll turn it over to you, sir. If you would please, struggling with my voice today, if you would please identify yourself and make your presentation to the board. Thank you.
I didn't see that. It's supposed to be about 2 feet.
Hello, everyone. Basically, after...
I'm sorry, could you give us your name?
Oh, Deron Jenkins, I'm sorry.
What was the last name?
Jenkins.
Thank you.
Basically, I submitted the plot plan that had an indication of 4 trees that were 2 on each side to buffer in between the 2 properties. But I ran into some slight issues, one being 2 retaining walls on each side, one which was not my retaining wall, but in building the property, I needed to shore up that retaining wall so that it wouldn't kind of come down at some point. So it took up a little bit of the buffer that I had initially planned to put those 2. One is a canopy and understory tree. And then on the other side, it basically kind of ran into the same thing in order to keep the gravel and the dirt from sliding down the street. I had to create a retaining wall on the left side also to keep that in place. I propose to move the trees and still place them on the property at whatever discretion that you guys would like.
Have you talked to anyone at Codes about this? Were there any alternate suggestions or?
Steph and I kind of talked about it. And, that's obviously what brought us here. And, I'm willing to do, sit down with him and get the number of amount of trees and whatever we need to do, keep it consistent with codes. Just have to figure out.
Really, the only other option that you would have would be this is perimeter landscaping, by the way, not a buffer. 5 foot is the standard, but you could also do 2.5-foot strips with tree islands. I don't know if that really helps him not, because the tree islands would have to be at least 5 feet wide, at least imagine a bubble along the strip. So it doesn't really help that much, but that is another option.
Would you say that it's a landscaping / green issue, or is it a screening issue?
It's a screening issue.
And
these trees are also serving for his tree density, but they can be put somewhere else on the site and meet that requirement. This is strictly for screening and perimeter landscaping.
Is a fence an option, an acceptable option?
Not according to the code.
I guess I'm not sure I understand the issue. I understand, the drawing I have, which is, it looks like the drawing that we're looking at on the screen, but it looks like it was done by the computer, and this looks, at the bottom, looks like it's hand done. It's showing 5 foot. Are we saying there's not 5 feet? I saw the picture with a whole gravel lot, but are we saying it's not possible to put in a sidewalk with the space that's there and have the 5 foot?
This is not a sidewalk issue.
The driveway. You can't pave the driveway and still have 5 feet on either side for trees.
According to the applicant, no. Is that correct?
Correct.
But and that is only because of a retaining.
Well, I'm sorry.
No, go ahead.
Oh, a retaining wall, and as you see on the property, the driveway is also, the entrance to the parking lot is also on the right-hand side.
Right.
I'm sorry.
No, right. Okay.
Yeah, and which means that I can't move that either, because they have the the NES wires coming down in the sidewalk. So there was really no other place that I can even put.
Right. I guess I'm not sure why it ended up. The drawings that were submitted look like it could be done, and then in reality, it looks like it can't be done, and I'm wondering why there's a difference. This is what I guess code's approved to give you the building permit to build your building, right?
Yes, sir.
Okay.
So, yeah, and what he's saying is, if you add up the numbers, the 5 feet, the 18 foot for the parking stall and the 5 foot, that leaves a 23-foot drive lane. So where is the retaining wall on the property line on the left side, or is it on your side, or?
When you say left, which
okay, well,
left?
As you're looking at the plan, the site, or the
site
I guess
plan.
this as well, that side is the retaining wall on the property, on the other property, on your property?
You see where Joey's drawing your arrow?
Right, I know where it is, but I'm asking him.
Oh, okay.
Is it physical? It's not on this drawing, so I don't know if it's on the property line or.
It's on the property. Yeah.
Right on the property line.
Yeah, it's probably maybe a 2-foot strip in between that and the property line.
So I'm kind of with you. I'm not understanding where you're proposing to fix. What's the fix? What's the recommended fix?
I don't know if there is one. I think he's got such a narrow parking area that he can't do both sides of the side perimeter strip. That's what the variance he's seeking. I can't. Can you do one?
Can anything grow in like that 2-foot area? You know what I mean? Like
I think he's looking for both. Because again, the tree has got to be a tree every 50 feet along each strip being on either side of the parking area. That's the side perimeter strip.
And he's got this fence in one area.
He's got a retaining wall in one area and a fence in the other.
There's actually 2 retaining walls, one of which you just can't see, which is being hidden. But there's
by the fence?
Yes, ma'am.
Okay.
Yes, that's the issue.
And is that your fence?
Sir?
Is that your fence?
Yes, sir.
Yeah, I mean, I know that, when you said a minute ago, and the other property isn't on our agenda today, but you said you own the adjacent property, and there's just not a tree on either one of them. I'd like to see a landscaping plan. And
I just purchased the other property, though. I didn't. Yes.
Okay. But I just think it would enhance both properties to have. If this is your opportunity to plant trees, I don't feel inclined to just give a blanket variance to say no, you don't have to plant the trees in that strip. I really would like to see, a plan. And if you can't get 4 cars in by having it on both sides, and you give us a proposal for one side, I think that's something that we would consider. That might be a hardship. But I guess what I'm trying to figure out is what is the defined hardship, and I haven't. If I've been told I'm just dense and I hadn't sunken in,
the hardship would probably have to be the topo. Yeah, I mean, the topo, the slant of, it's obviously going downhill from the right to the left, and in order to keep, the earth from sliding further down the hill was the reason why I had to do the retaining wall on the left side, and that took up I'd probably say about 3 feet. To do that. If it had not been for that, then I would have had the 5 feet that I would have needed to put it there on the left-hand side.
Which property is yours? The other property? The one on the left there?
Yes, sir.
Okay.
Question for you. If you, more because of some greenery and buffer is an issue, have you entertained any bushes that we could do along the street sidewalk area or down the side of the fence that might give address some of that issue?
These two.
Not really?
Well, that doesn't really address that specific part of the code. That specific part of the code is providing screening to the adjoining neighbor. Now, he happens to own that adjoining property, right, but the other side,
he's got a fence.
He's got a fence. That's really what it was for, to screen neighboring properties from his parking area.
So do we need, I'm sorry for my ignorance on this, but do we need the screening and the landscaping? Is the fence required?
The fence is not required.
But there's still there's still a retaining wall on the other side of the fence. Is that correct?
Yes, sir. But it's the retaining wall of the gray house.
Right, okay.
But
Is 1909 that neighbor? Is it the person?
Oh, no.
Do we know? Joey, do we know where the letter of opposition came from? It's 1909 Herman Street.
Yeah.
Oh, yeah, that is.
That's the gray house?
Yes, sir.
And just for the record, it says that it would add to the beauty of the neighborhood. I would not like to see the existing townhomes without the required perimeter landscaping. So that's her opposition in a nutshell.
I don't even know how it would even apply to her.
I mean, do you have any recommendations on where to put these? And you're the expert.
I think in order to do what would be necessary to satisfy the ordinance and me, I think he would have such a narrow parking area they wouldn't be able to maneuver.
Right.
So.
And to me, that's a hardship. I mean, obviously, parking's very instrumental to this.
You could almost call this a narrow lot, but
well, and there's
in some ways it's also
issue.
Self-imposed.
There's a topographic issue with the retaining walls. If the retaining walls weren't there, you could plant the tree, but I don't think it's not an ideal location to plant a tree if there's a footing and.
Well, they would have to put they would have to put mulch and take the gravel out and put in a 90 square foot planting bed for that tree.
How many square feet?
90 square feet.
90.
That's
a parking space.
That could be. That's about a little more than a half a parking space. You can push and pull that 90 square feet any way you like, but it can't be any narrower than 5 feet.
How many units are you talking about? You got 4 units? Or
But
3 units?
you would still have to have 2 trees on each side.
2 trees on each side and put the other 2 somewhere else on the property.
And the 2 trees, let's say hypothetically on the left, would have to be in one of these islands or in 2 islands?
According to the code, it's supposed to be on one on each side of the parking area.
And for our counsel, Mr. Lawyer, sir, are we allowed to split the baby on this? Or are we to...
What do you mean by split?
Well, because he's offering a suggestion that, well, first of all, he's asking for a variance, right?
That's correct.
So we can say, yeah, you have a hardship, and he doesn't have to do any of the trees.
And I know this is not what you're asking, but as long as the hardship is not viewed as being self-imposed, and that's, of course, in your 7 criteria for granting a variance.
And if there's somewhere between those two, doing what it says, or what the code says, or doing a variance, that's the splitting the baby part, like, can we say, plant 2 trees somewhere, and there you go.
I believe that's been done, and I believe that you can.
Where would you recommend he plant 2 trees?
I'm not, I was saying hypothetically, he's saying you got to do 2 of these trees in 2 separate islands, and you can put 2 other trees somewhere else. I was asking if we had the authority, since he's asking for an exemption on the whole thing, can we say, well, if you'll do 2,
Or just do
one of those
side.
2 options, we'll let the other 2 go or whatever. I don't know if the board's interested, I'm
I was
just,
going to say, it seems to me that you're, I'm sorry.
The public hearing is still open.
I'm just trying to understand before we ask him another question, is there a location in your mind that this could happen? I mean, we need to ask the man if there's...
no, I'm not proposing any specific plan at the moment. There appears to be some wiggle room agreement between them, and I was just making sure that we could, if we come to an agreement, that we could indeed approve that agreement, which I think.
Okay, so I was
You're saying we
unnecessarily confused.
I agree with
I was just trying to be clear
No,
with
I
our.
get it.
I was just trying to be clear with our council that we
I
could
get it.
approve
Okay.
some
I think
variation of what he's asking.
I understand. I thought you were going down a road, and I was trying to stick with you, so...
I don't actually have a plan here.
Okay.
I think we may be bordering on
Yeah, discussion.
discussion of the case already.
Well,
If you
I guess
have any questions,
My
if
question
you have.
for him was, is there intention for any other landscaping on this property? I mean, you're showing a plan, and which part of this plan are you trying to be consistent with?
Well, actually, every other part of the plan is complete. What I was going to propose is to put the trees that I can put in the common area, which is behind the property, which you can see on the sheet.
Okay, so you
plan.
have intentions of planting
Yes.
some trees there?
Yes, correct.
All right, so you're not asking for a complete variance, just
Correct.
for how many trees?
He's
Just
gonna
the
plant
4 right
trees.
here and the,
He's going to plant the trees.
I'm gonna
He
plant-
wants a variant on the perimeter strip.
Yeah, so he wants to
Just the
plant them in the
perimeter.
common area.
So
Okay.
is the buffer required on both sides of the
The
landscape?
perimeter strip is required on both sides of the parking area.
And he is presently asking for exemption from both sides, am I right?
Sounds that way, yes.
But you have intentions of taking these 4 trees that are shown here and planting them back here on the common area next to the fence area?
Well, there's a common area behind the property, too.
Okay, we just can't
Yes,
see
that's
that
here. Is it? They don't see that out there?
When you say behind, we're
what's
exactly
behind?
talking about on the drawing.
They don't have
The top of the
Oh,
drawing,
I thought you.
is that what you're talking about?
Yeah. Oh, yes, ma'am. Behind.
Up here at the top?
Yes.
Okay.
Correct. Yes. I'm sorry.
Thank you. Because they're not showing any trees there, so
Yeah,
I
that's
didn't realize, okay.
No, that's what I was
Okay.
saying. I would put them. Obviously, this was the initial.
So you're going to compensate and agree
Yes.
to take care of planting the trees? You
Yes,
just
ma'am.
can't achieve because of the
On the sides.
narrowness of the lot on the
Yes,
2-side perimeter?
correct.
Okay.
And
I'm a
just-
little more clear now as to what the problem is. Okay.
Okay, and then I want to get from you and from codes a better sense of how we got here, because the lot size didn't, I don't see that the lot size changed between construction and now. I mean, it's always been 51 feet. I know that there's a retaining wall, but I don't see it eating up, 3 feet or 2 feet. I mean, it's there. It still seems to be on the property line. It appears from the photo to be about as wide as a fence or a fence post. So it maybe a little bit bigger, but we're not talking about a foot. We're talking about somewhere less. And so, I still would like to see a solution that has some type of green space in the front of the yard. And so I want to make sure that if it's on the side where that retaining wall is, that a 3 foot green space that had maybe understory trees and not a canopy tree, which I think takes more. If that were the case, then there would be still room for parking and maneuvering.
On which side?
The one where the retaining wall is. And the understory trees, arborvitae.
There's only about 2 feet on the other side of that retaining wall right there.
Right, I'm talking about planting it on your property side of the retaining wall. Where the silver car is.
He's saying you have to take 90 square feet to put a tree, right? So it's
not an understory tree. What
does that require?
Well, theoretically, an understory tree would have less rooting space than a canopy tree.
Right.
What
does that require as a planter?
Well, 90 square feet is what we've always used.
Yeah.
If you want to vary that,
right, but the drawing proposed has 5 feet by
on both sides.
Length on both sides, but we're planting a canopy tree in 5 feet times whatever. I mean, it's not 90 feet square. It's not a 9 foot by 10 foot
right.
plot.
It could be 5 by 18.
And there's a 3 foot by 30 foot gives you your 90 feet to plant all kinds of stuff. I'm just saying, all I want to know is, I would be more comfortable if there is green in the front of the building.
Breaking
and
that
my
up.
question is, if there were a 3 foot strip where that silver car is all the way down to plant either understory, it sounds like a canopy may not be the appropriate tree.
On the right side?
Between the red car and the silver car.
Oh, okay. On the
right, yeah, where the arrow's going up and down. The code. I mean, what y'all agreed to with the permit. What everybody signed off on was 5 feet on either side, and now it looks like that's going to be tough. So I'm just saying, what can we do to make it on one side?
Well, I guess a bigger.
Let's make that part of maybe
that's part of the discussion.
Well, the question, and again, not to get into the debate, the question was, will you still have a big enough parking lot to maneuver and, to both of them?
I mean, I think that's part of, we can certainly ask that, but it'd be part of discussion too, because I'd venture to say that make it impossible for you to back up, to park in there, back up, maneuver, but we can have that conversation, but let me ask you this, and I think for people's sake that aren't in the industry, was there something on this lot from the moment you got permitted, an unknown condition, a topography issue that arose that created some of the issues you didn't initially have to address?
Yes. On the right side, the side that the fence is on, the lady that wrote this letter, I actually spoke to her. The fence was about to fall down. And I asked her, would she fix it? Would she be interested in, and I even asked her, hey, I pay for a portion of it to get it, kind of shored up. And she declined. And so from that point, obviously me building, it's my building, so I have to make sure that at some point it doesn't fall on my property. I had to shore it up. And in doing that, I took some space away because obviously you have to do that before you can build any building. You know what I mean? I have to make sure it's secure. So I took probably 3 to 4 feet in doing that in different parts. If you can actually see, if you look and you see the fence, how it bumps out, like it goes straight in, and you see that part right there, that was a part of why, that part of the fence was even worse than the front part of the fence.
Did you install a whole new fence?
No. I'm sorry, ma'am?
Is that a whole new fence?
Yes.
Okay.
But what I had is wall ties actually are behind that fence to shore up her retaining wall. And so that's what took away from this. That's correct. So once I cleared the lot and I saw the condition of that old retaining wall is when I approached her and she wouldn't help, and then I just fixed it. And so that took away the buffer that I initially thought I had.
So that's from your intention when you filed the plans without knowing it, you had
Right, because I mean, it was full of like old trees and just trash, and you really couldn't even see the lot until I cleaned it, and then I saw it.
Okay, thank you.
Any other questions? Evan, anything else to add?
Not really. I think putting a 3-foot strip is certainly better than nothing. And we still put the trees out somewhere else, or we can put a couple understory trees in that 3-foot strip. I like that idea.
Can they grow in, is that a big enough area? I'm fine. I mean,
Keep them watered.
Okay. No, it's fine. No, I just wanted to make sure if I put them in, is that big enough? Is the 3-foot strip that big enough? That's fine with
For
me.
an understory person.
Yeah, no problem.
And you're willing to do that?
Yeah, absolutely.
Hey, Joy, I guess we can close public hearing.
Let's close public hearing on case 78.
I would really like to see some green in the front, and whether it's, if we limit it to understory, crepe myrtles, arborvitae, just something that says we made an attempt. And I get that. I think that there is a hardship in terms of the fence. From what I hear, it's 2 to 3 feet. I think there is a hardship with the retaining wall. If that's right, that's 2 to 3 feet. I think that negates one of the 5-foot planters, but not both. And I think there should be some planter of some sort in the front of that property. And
he said he's willing to do it, so I mean, we can beat a dead horse, but the man's willing to put it.
No, so that would be my motion. Would be to grant the.
I'll second that
the
motion.
variance as long as there's a 3-foot planter strip.
Second.
Okay, we have a motion and a second. Everybody understand the motion?
Mr. Chairman, can you
Did you get the motion?
rephrase that for me, please?
You want to read? Were you making a motion?
I think I did.
I thought you were debating.
Well, after I was told the horse was beaten to death, I thought I better force it into a motion. So that's what I was trying to do. I guess I move that the board approve the variance because all the requirements of MCL 17.40.370 have been met. We find the unique characteristics of the property are the fence that had to be installed and the retaining wall, and therefore we would grant the variance of the planting on both sides of the property and require that one planter of 3 feet be established down the left side of the property.
I second that motion.
Okay, we have a motion and a second.
Before you vote, you're telling me that I want to make sure that the topographic conditions and the fence are all related, the hardship on that, right? Okay.
And the narrowness of the lot, right?
Okay, all in favor of the motion, say aye.
Aye.
Opposed? Motion passes.
Okay. The board adopts on a vote of 6-0 with the condition stated 3-foot wide strip along the southern property line that's on the left-hand side facing it with understory trees in that area.
I didn't know you were making a motion. All right.
Thank you.
All right, Mr. Chairman, we'll call the next case, case 2012-79, Beezer Homes, the appellant, the Townhomes of Bradburn Village Association, owner of the property located on Pinhook Road, requesting a variance in the irrigation standards in RM9 to use the Bradburn Village development with hose bibs instead of irrigation. Referred to the board under section 1724.080B. The appellant has alleged the board would have jurisdiction under section 1740.180, item B. The subject property you see is located on the north margin of Pinhook Road, just east of Murfreesboro Pike. This is directly behind the shopping center, which you see on the aerial photograph. I believe there's a new public store and several other retail establishments that have been built there. Bradburn Village sits on Pinhook Road, east of Murfreesboro Pike, and you see the aerial photograph. Now, it's a little dated. That aerial photograph's about 15 months old now. But this is page 1 of a 3-page site plan. I did not post all 3 pages on here for you, but it shows the landscape plan that was turned in by the appellants. Just looking into the subject property, standing out on Pinhook looking toward the development, the signage that's out here in the landscaping areas. This appeal deals with the entire development. So the photographs I'm showing you here are not specific to the hearted issue. It's throughout the development in instances where, by way of the prior zoning administrator, Mr. West, interpreted that multifamily developments like this required their irrigation to be their.
Joey, can you say it a little bit louder? I'm sorry, I can't hear you.
I'm sorry. This appeal really deals with more of an interpretation from Mr. West. He required that developments, multifamily developments like these, the code allows you either hose bibs or underground irrigation. We have applied always irrigation to multifamily developments like this. So the appellant is here appealing to you to wish to use the hose bibs as has been installed versus the irrigation that is on the plan. Yes.
So that's still interpreted in our code. I mean, even after all the, I know the mayor has all asked us to conserve our water, and, after the flood, that we were requiring someone to have irrigation.
This state wrote an executive order, I think it was 2003, maybe 2004, requiring townhomes and condos. In other words, multi-developments, but not apartments, to put in irrigation, because the thinking there was when trees, if and when they do start to die, we would go after homeowners association would be a multitude of people that would be taken to court. So the thinking there was, let's tip the balance or tip the odds in favor of the trees a little bit by requiring irrigation. He did write an executive order. It's not in the ordinance, and it only applied to townhomes and condos.
So what's the challenge in getting these trees watered with a hose bib? Somebody actually then
because it doesn't. It very rarely happens. They never get watered. Even if they put gator bags, if you know what gator bags are, they never get filled up.
But is this a problem in the city of Nashville that where trees are dying and?
Yes.
So how did this project get built without an irrigation system?
Well, the plan showed a requirement of irrigation.
Okay.
Or they were offering to do irrigation, and it stood on the plan there.
But it did not get installed.
Correct.
Okay, we'll ask them that. Okay.
And how is the city responsible if a tree dies under these kind of situations?
They would have to write, I send a debate notice out this time of year, maybe September, so I can time it so that they're replacing trees, have to replace dead trees in October, November.
How many dead tree notices did you send out this year? For units like this?
For like this?
Yes.
Probably 20, 25, all told, probably 50, including commercial properties.
And when you send out the notices, do they get replaced?
Most of the time, yes.
So doesn't those notices kind of take care of the problem without requiring this?
I suppose it would.
How long has this executive order been in place?
I think it was 2003, 2004, something like that. As best I can recollect.
Around 8 years. And then I'm relatively new to the board. How many times has it been challenged? Is it frequent that it's challenged? Or
no, it's most people when they are told up front before they get a permit that they need to put in irrigation. They usually do. They always do.
Okay, thank you.
Let's go back and let our appellant state the case.
Sure.
May put some light on the matter here. Go ahead and state your.
Mr. Chairman, thank you. My name is Tom White. I'm with 2 Nashville White. I'm located at 36 Old Club Court. I really don't know this matter before the board as a variance in the first place. As the ordinance is read, the ordinance is extremely clear. It says you can do the irrigation system or the hose bib. That has never changed. I frankly was unaware of the order that Sonny West had down, and with the greatest respect for Sonny, it doesn't trump the zoning ordinance. I mean, the zoning ordinance speaks for itself, and as Mr. Hargett has read to you, it's very clear you can do one or the other. In this particular case, to my immediate left is Mr. Davis Lamb, who's in charge of land acquisitions for Beezer Homes. He was not the individual with Beezer at the time this development came along. But basically, what happened was when we found out the circumstance, because Mr. Lamb was not the individual president at the time, he contacted me. And the reason it came up is not because of any complaint of anything. There's nobody said anything's died out there. The issue is everything's fully planted, it's fully landscaped, it's all in place, and there's been no issue about any diminution in the plantings that are there. But when we came down for the final master plan permit with everything totally finished, the issue came up, and I contacted the board through the staff and said, you can do either one, and that's the first time I heard that there was this executive order down from 2004. And I frankly said, can't we do this administratively? And they said, well, the better practice is when we put it in front of the board, we're not going to have opposition to it, but you ought to do the presentation to the board. So based upon that, I contacted the councilman from the area, who's Mr. Robert Duvall. He went out to the site, he looked at it, he saw that everything was fully in place as it should be. I asked him to contact the staff, as they'll verify he did, and said he had no opposition and thought it was a good idea. The other thing that I'll mention to you is that with respect to the watering, remember this, we've got all kinds of watering issues through the very dry summer that we've had right now. If you have the irrigation system up after it's fully mature and you water, you waste an incredible amount of water. If you have a hose bib, you take the hose bib out to the plant that dies once it does. We don't have any that have died, but if it does, you could take the hose bib out and water just that one. It's very specific. It's very indigenous to that tree. The homeowners association is now responsible for the water out there, not my client. The homeowners are clearly supportive of this request because they don't want an irrigation system all the time that's wasting a bunch of water. So it's not our money, it's the HOA's money. The zoning ordinance is extremely clear. It can be either one of the two. And we don't know of any opposition to this. Again, we've gone to the council person, and with all deference, the code says it's either one. I don't know that it's a variance. It's probably more like an item A case under 13.728 where you make a call. But I do feel like, in fairness to the general public that don't have access to the executive orders, we've got a zoning ordinance that's extremely clear. So for that reason, I don't know if it's a variance, but we said this was the best practice. Again, I urge that it should have been done administratively, but my clients here will answer any questions. There was nothing intentional, nothing devious, and you've got everything out there fully landscaped. Everything's alive. It's just a question if we came down for the master plan at the end of the day and this issue came up, we couldn't get a sign off until we had this addressed. So we'll answer any questions. Mr. Lamb is here. Again, he wasn't the land person at the time this was developed, but that's our request.
So I do have a question, Mr. White. Why are there proposed hose bibs on this drawing if everything is okay? It looks like there's existing hose bibs and proposed hose bibs.
I'd like my client to answer that. He can tell you exactly why.
I am fairly new to Beezer Homes, started there a couple of years ago, so I requested from our engineer and landscape architect the plans that were approved. The plans that were provided did not show irrigation system. And I don't know if they're accurate for what the approved plans on file were, but they were the plans that the landscape architect and engineer supplied with me. We took those plans with the landscape architect. He went to the field to evaluate all of the landscape material and the hose bibs to figure out what was still alive, what needed to be replaced, what was missing. There were several hose bibs that he did not find in the field. And so what I assume, I'm not sure the plan that you've got in front of you, but I suspect that it's the original plan we had that showed proposed hose bibs. We've gone through and replaced those hose bibs, added hose bibs, made sure they're all within the 100-foot, I think it's 100-foot radius, and replaced any dead materials that were out there. And it was after all of that was done that the question came up about, well, why are these hose bibs and not an irrigation system?
When did that happen?
That was June, the end of May, 1st of June, something like that.
But are you saying that the original plans that were approved only showed hose bibs? There was no irrigation plan that was on there to be approved?
That's correct. That's okay. The plans that I was working from did not show irrigation. It showed hose bibs.
But Joey, does the applicant have the same plan that we have?
plan on screen is the one that's in the file. See this? Now,
Well, that's not really in color. So,
it's a little fuzzy.
well, and what I'm trying to figure out on the drawing that we have submitted in the package, I haven't looked at this one yet, it's actually indicating it's got some dead trees that need to be replaced.
All of those dead trees and all of the proposed hose bibs have been replaced. And
But you guys just said that everything was fine.
the way that I understand the process, the burden is on the applicant or on the developer to hire a landscape architect, and the landscape architect has a very distinct sign-off that they have to make, which, my understanding from these plans, all of that is done.
Plus, I want to clarify, Mr. Harper, that when my client finally came ready to get the final master plan sign-off, just to make sure everything was done correctly, they got the landscape architect back involved, who went out to the field, found a couple things that were not alive at that point. They were all replaced. When they were out there, their plan also showed that certain hose bibs were to be in place. Virtually all of them were. Some were not there, so they put those in at the time. Then with the plan in front of you, they came down to the department to say, we're now ready for a sign-off. Every department signed off, but the issue came up of this executive order from Mr. West from either 2003 or 4. And when I looked at the ordinance, which is 17.24.080, as read by Mr. Hargis, it's extremely clear. You can do either of the two. And
Okay, so now this plan is an as-built. What says proposed is no longer proposed, it's in.
That's correct. That's correct. There's one question on that plan that the landscape architect has to answer that says, is the irrigation provided? And the irrigation provided based upon the plan is yes, but that's where we're trying to clarify that to make sure that there's no confusion with that.
So what would the note 2 under this plan consist of, where it states existing irrigation and hose bibs? What irrigation are you referring to?
I'm not sure where he is.
Mr. Chairman, I'm not sure which note you're looking at.
Looking at the bottom of this.
It's in red.
Right by the north arrow at the bottom.
This is revised, right?
Yes.
There is irrigation at the entrance. I don't know if that's what it's referring to. The entrance wall itself is irrigated, but there is not irrigation. There's only hose bib system throughout the subdivision itself.
The front entrance, we think, is fully irrigated.
Yeah, I'm sure it is.
Just wanted to confirm that I checked with Urban Forester. I think everybody's in agreement. The entrance is fully irrigated. There's no question about that. That's been that way from the outset. It's the remaining parts of it that are the issue of this revised plan.
Approved plan. I'll highlight it.
Yep.
That note there.
Yep.
And this does not show the hose bibs. This is the original plan.
So before we let our applicants go, I just want to clarify that we're asking to approve a variance in based on the executive order.
Let's wait until.
Well,
Is that right?
essentially, you'd be approving the as-built vis-a-vis the plan submitted. And then, going forward, we'll look at revising our, it's been crafted as an executive order. We call them something different. I know Stephanie used that term.
Okay, I just wanted to know, in case I had any follow-up questions, what it is I'm asking. If we're doing a variance, we have to ask what the hardship is. But I'm still confused as to what it is we're being asked to vary.
And Mr. Harper, that's something I want to clarify during the public hearing. It's on here, it's categorized as a variance. And this board under 13.7208 has got 3 different authorities. The first one is the item A case. I really think it's an interpretation more than it is a variance, because we all know for the variance you need to show the narrow, shallow topography, as we heard in the case just before me. I'm not claiming that variance and that hardship. I'm claiming it's an interpretation, and the zoning ordinance clearly trumps any executive order. I mean, it's just that basic. And I don't know know in what publication the executive order's in. All I know is what the ordinance says, and that's extremely clear, and it's been cited to you by the staff. And in good faith, my client Beezer's got an excellent reputation in this community. They're not down looking for variances and exceptions with any type of regularity at all that I'm familiar. We've represented them for many, many years. And here's a matter where Mr. Lamb, as the new land use person for Beezer, came along and they were making sure everything was done correctly at the end of the development. They found out there was this issue. The front's fully irrigated. They checked, and in the back areas, there's basically plants were all fully alive other than a few. They replaced those. They made sure the hose bibs were not only in place but within 100 feet of all the plants. And the HOA has no opposition, and they wouldn't, because it just wastes a whole bunch of water to irrigate everything instead of specificity. That's everything, and I think it's kind of a common sense resolution instead of a variance, because I can't claim a narrow shell, and I don't want to assert that in front of the board.
Tom, I understand exactly what you're saying. What I want to understand is that was the plan approved with the hose bib shown?
I am not positive. I've seen conflicting things here. It looks to me like one of the plans that the urban forester showed me showed a plan that showed irrigation on it. Now, I want to clarify. It says proposed plant materials will be watered by an irrigation system. This is from a plan that was many years ago. I wasn't around when that was done. I can't question that. But I want to assert that the front of the development was fully irrigated. But from the very beginning, it was the hose bibs in the back. And we were inspected at every stage of the game. I mean, it's not like this is an entire development that the board's seen here. It's not like this was a red flag and we kept dodging it. But year after year, with all the Metro inspections, no one ever said anything. And this was a pretty significant development, as you can see, that went through many inspections, and it didn't come to light till we came in at the very end and said, by the way, we're looking for a master sign-off here. And that's when this issue first came up. So again, if it was something that was inconsistent with an earlier plan and was of any significance, surely somebody would have said something as we came through.
So why did you file an item B variance and not an item A appeal?
Frankly, I filed it because after discussing it with the staff, I felt like a variance is probably the language that I should put down here. And again, to be perfectly honest, I thought it was a matter that would have been on the consent agenda. And when it wasn't, and I started thinking about it sitting here, I thought, well, I think it's probably more of an item A case than a B, to be honest. But under these circumstances, it just seems that it would be a total waste of water to do it any other way. And if this was at the very beginning, my client would do whatever we were directed to do. But I want to insist, isn't the basic issue here, what does the zoning ordinance require? It says either or. But
that is an item A argument, and I don't disagree.
But we're here under a variance, and that's just what we're here for.
But my point is, no one is claiming a hardship. Actually, no one's claiming a variance. You know what the variance would be. What are we being asked to approve exactly?
Should we close the public hearing before we go?
No, I need the appellant to make the case for a hardship and tell us or request a specific appeal.
I'll give you
a variance.
I'll give you that language. I don't have it in front of me, but 13.7.208 says this. The first one up is item A case, which is the interpretation. If you look at the section which is next down dealing with variance, what the language says is unusual shape, topography, et cetera, or other circumstances that the board considers. And I don't have the language, but anybody here that's got the code can look at that. It says, or unusual or exceptional circumstances. And in my opinion, the unusual or exceptional circumstances here don't have to be narrow, shallow, whatever. It basically is a matter where you've got a development where it's totally finished, where all the plants are fully alive, which everybody will confirm.
And I follow that.
That's why I think
I follow that, and I agree with it. But
that's variance language.
Yeah.
Yes,
Mr.
So what are?
Can I speed this debate on, because I can solve this since I'm your secretary.
let us withdraw this case as a B, and it needs to come back. We'll file it as an A. No charge to the applicant, since it's clearly the mistake of myself. So I'll save this discussion, and then I think that's the best part to do, because it really. Well, it's really more of an interpretation, and we've advertised it as variance, and y'all can't be discussing interpretation sections.
But it does sound like we could approve it as a variance.
You could.
Based on the language that Mr. White had said, other circumstances, and that way it's not even a precedent setting.
But it's redundant.
We don't have to determine it.
Because they're not asking to do anything that's not in the code. I mean, it appears by their argument that their drawings do meet code, and no one's arguing that it doesn't meet code.
Well, I think I agree that we could look at it as a B and talk about other circumstances rather than making them come back.
We would certainly prefer that in order not to come back twice.
Well, and I would prefer not to have a precedent-setting case on something that has happened rather than something that's going to happen. I'd much rather debate that issue on a proposed plan, not on something that's saying we're trying to wrap it up.
And I'm in agreement with that, too, so I think we have
I'd like to keep it like it is.
Okay. Do we have any other questions for the applicant?
That's okay with you, Joe?
I'm trying to get it in front of Dave.
Well, that's what I want to make sure. I just don't want to create any kind of procedural problems for our order if really, it should be an A.
Yeah, see, I'm not, and I would, again, defer to our counsel on this, but I don't know, I don't know that we, A, can find a hardship, or B, define what the remedy is.
Let's hear from our counsel.
If you're wanting to take an action one way or the other on the variance as is presently before you, yeah, you're going to have to meet those standards. But to the extent that you feel like this is one that shouldn't be just a straightforward consideration of a variance, it's not at all inappropriate for staff to withdraw, have it refiled as Joey laid out. It's not a bad idea at all procedurally, because it does keep it more clean and keeps it careful in the way that he's able to notice what is being put before the board. Not just this case, but is it coming as a variance request as opposed to an item A, as opposed to a special exception or whatever else it may be. To that extent, there is some procedural strategy. Some strategy like against or for, but
would you mind reading that section of the variance language which Mr. White paraphrased?
And forgive me, I was looking at something else at that moment. I assumed you're in 13.7.208.
13.7.208, the second section that talks about narrow, shallow topography or other exceptional circumstances, is the language both in the TCA and in the Metro section.
Give me that again. I'm sorry. Which section?
13.7.208, the first section up is the item A. There are two other sections underneath it. One variance, one deals with special exceptions or conditional use permits, and it's the language that you'll find there that reads narrow, shallow, or other exceptional circumstances.
So if that's your argument, how is the shape of this lot preventing irrigation versus?
It's not the shape of the lot. It's the other exceptional circumstances, which are in this case that the zoning ordinance is extremely clear. It's either one or the other. And the circumstances that we've come through every inspection from the beginning of this project until now, and only when we came in for the final permit did this come up. I think that's an exceptional circumstance.
And I wanted to share that applicable section of the code in the tradition of my predecessor in this board, Doug Sloan, reading through the code at great length during board's time. I wanted to find the right one. Section under 13.7.207, which outlines the powers of the Board of Appeals, subsection 3, states as follows: where, by reason of exceptional narrowness, shallowness, or shape of a specific piece of property at the time of the enactment of the zoning regulation, or by reason of exceptional topographic conditions or other extraordinary and exceptional situation or condition of such piece of property, the strict application of any regulation enacted under this part and part 3 of this chapter would result in peculiar and exceptional practical difficulties to or exception or undue hardship upon the owner of such property, authorized upon appeal relating to the property a variance from such strict application so as to relieve such difficulties or hardship, provided that such relief may be granted without substantial detriment to the public good and without substantially impairing the intent and purpose of the zone plan and zoning ordinance. Council would note that that is actually one sentence.
Thank you. So do we have anything else for the public hearing?
I don't think we have any more questions.
No, that's the section I was referencing. I appreciate the courtesies and council taking time to read it. I couldn't tell you exactly verbatim, but that was obviously what I was talking about.
Okay, so we're going to close the public hearing.
Joey, you can discuss.
Close the public hearing.
I will close public hearing on case 71.
Any discussion? Otherwise, I'll make a
I certainly
motion.
think it fits right within.
It clearly does, and I hope that staff or Metro deals with this memo that Sonny wrote, because I think, given the droughts that we've had recently, and given that, irrigation is not really seen as necessarily good for the environment for all properties, I think this is kind of an outdated order. But I agree with what Ms. Garrett is about to say.
I'm going to make a motion that we approve the request for a variance on the basis of other extraordinary circumstances, including the fact that this is an existing site that was approved, and that it's been approved by Metro over several years based on the applicant's testimony, and I wish I had that language in front of me.
Executive order versus.
And I'm basing it on, can we see that language again? Sorry, I'm going to hold that motion.
John Michael?
Yes.
Okay.
I'll make sure I have the right thing.
Wait a minute.
I have it written down.
Oh, I don't think you've got the right one.
No, I think
No,
it's
I would want that section.
John Michael, your section.
You want your green book.
I don't know that I can vote on this issue. It seems like.
Well, we haven't gotten the motion fully.
No, I'm saying I don't think we can vote on the issue. I think that it's an inappropriate appeal.
Allow me to finish this and see if you change your mind.
I thought you were on hold for a second.
Start from the beginning. Let's start that motion again. I move that we grant this variance on the basis of other extraordinary and exceptional situation and conditions of the property with respect to the strict application of the zoning ordinance as interpreted under the executive order, which would not be appropriate in this case based on the fact that the property is existing and has passed with the approval of Metro over several years based on the testimony of the applicant.
Okay, I'll second that.
Point of clarification from our counsel. Would that motion be interpreted under a item A rather than this?
I think it's just a regular variance request.
Okay.
We never brought up item A.
I know, but I mean, as the motion was framed, I just wanted to be sure it could not be interpreted. As
Clarify that motion is based on a variance.
Okay.
Yes. Okay.
And my second is based on a variance.
Okay, we've heard the motion. Any further discussion?
Sadly, I do have just a little bit. I still don't understand. I understand the motion. I understand the theory behind the motion. I don't disagree with it, but we aren't varying anything. The applicant is not asked.
We're varying them not having put in an irrigation system.
We're granting them a variance from the requirement that they put in the irrigation system based on.
They're asking for a variance of the interpretation, not
They're asking you not to have to install an irrigation system.
because of an interpretation. I'm not trying to
Because
put.
of something that's not public record.
Right, and what we're saying
That's
is
fine, but I still think that's item A and not at issue here. Because in the end, if we approve this, correct me if I'm wrong, we have not given them a relief from anything except an interpretation.
We've given them
Which
the
is an
right
item
to
A.
put in a hose bib instead of irrigation.
Which is in the code. Therefore, it's not a variance or it does not vary from the code.
The applicant cannot get a permit until they get some sort of blessing from us, and so that's, if it were so easy, they would have gotten a permit.
And
So
all this motion says to me is that in this special case, because of unusual circumstances, this is what we believe. And it says that we're not taking up an item A interpretation issue of it because in my mind, it's not, I don't think it's the case to decide that. hose bib versus irrigation system. I think it's an unusual special situation, and that's what we're talking about.
And the motion said based on this specific piece of property.
So
And the extraordinary circumstances, correct?
Yes.
You ready to vote?
All right. We need a second.
you got a second.
You got a second.
Okay. Any other discussion? All in favor of the motion, say aye.
Aye.
Opposed? Motion carries.
One abstention, Mr. Chairman.
What's it? Oh, what's that?
Okay, Mr. Chairman, we'll call the next case, case 2012-83. Mr. Kevin McGinn is the appellant, Glenn A. Ferguson, trustee, owner of the property at 2151 Ackland Avenue. They are requesting a special exception for street setback and sky plane and variance for rear setback in the RM40 district, UZO, to authorize construction of 20 townhome units on the property, referred to the board under section 1712.035 and 1712.020. The applicant has alleged the board would have jurisdiction under section 1740.180, item B. Applicants present, any parties, additional parties present who wish to speak in support for a case? Any parties present who wish to speak against case? Okay, no parties besides the appellant wishing to address you. You'll have 10 minutes to present your testimony. Let me go over the record for the board first. The subject property is located on the southeast margin of 24th Avenue South and Ackland Avenue. It is in the RM40 district. The subject properties involved are these three parcels that you see here in red. Orientu Fannie Mae Dees Park to the northwest. The Eakin Center located to the southwest. Again, Ackland Avenue here, 24th. This is the site plan that's submitted by the applicant proposing 20 units on the lot. The arrangement of them, dealing first with the special exception, they are proposing to set the setback line along 24th Avenue to be 7 feet from the property line and 6 inches along the property line on Ackland Avenue. This is a special exception by the zoning code. I believe you have comments from the planning department. I apologize, I did not look at those prior today if it was a recommendation for approval on the planning department did recommend approval on for the special exception request. Public Works also took no exception to the request. The variance portion deals with the rear setback. Basically, in a corner lot situation for multifamily and sometimes 1 and 2 family, you have to declare a front on this site plan. So in doing so, if you declare 24th Avenue front, then your rear yard ends up being the opposite line that is parallel to your front. In this case, the front being declared as Ackland, that requires a 20-foot rear setback here. This building is 27 foot and 3/4 inches here. This building will sit at 10 feet, and that's the variance request would be a 20-foot rear setback required here. The number of spaces shown on the plan do conform to the code. Public Works is permitting the use of the alley for these 3 spaces and the ingress egress. As you see, they have allowed for other developments along.
Is that common to use the alley as?
Yeah, it really is, especially in the urban area.
And does it take special permission, or is it?
It does, takes the approval of Public Works to allow that use. And those are generally called, initially on the front end, in our submittal to them for recommendation, they would generally let you know if they had an issue with it. They'll certainly look at it again on the permit end once plans are submitted and full drawings are turned in. I apologize. I do not have a color scanner in my office, so I apologize for that. You should have in your packet a color rendering of this, of the proposed elevation in similarity to what they're proposing here. But this is looking at the subject property. I'm standing on 24th, looking back toward the intersection of Ackland here. This view, again, along 24th, you see the existing structure in its distance and proximity to the sidewalk on 24th. These are the neighboring properties across the way. This photograph is looking north across Ackland, again to the northwest at Fannie Mae Dees Park. I'll turn back to the site plan as proposed by the applicants here. That's the case records. We have it. Gentlemen, if you would please identify yourselves and make your presentation to the board. Record purposes, Council Lady
Berkeley Allen.
Berkeley Allen, thank you. I was just here and addressed you. Also wanted to express our concerns about talking with Public Works regarding
She wanted to clear up the record. It was based on the other property, the Chesterfield, not this one.
Okay. And so with that, I'll turn it over to you guys.
Thank you, Joey. My name is Brian Hamilton with Nashville Civil, representing Mr. Kevin McGinn. And we were encouraged from the very start of this project to design, I guess, as you see, close to the street. And that kind of led into a series of events that brought us here. But in the course of this, we've had a neighborhood meeting where I guess about 400 people were invited to attend, and we had 2 neighbors and 1 neighbor that lived a good distance away. They did not deny that, based on the zoning code, this development is allowed. I guess the entire meeting was about parking, but the parking issue would not be because of this development. It would be because of a close university. And so we had good support there, and as Joey said, Berkeley Allen is in favor. This development has less units than is allowed according to the zoning code. And also, Joey stated that there were no exceptions from planning or public works. And at this time, I'll turn it over to Kevin again.
Well, thank you. I'm Kevin McGinn. I'm hopefully the future owner and developer of this property. Yes, the issues we ran into is we were working with Metro on the purchasing of, not the purchase of the property, but the development design of this property, tried to develop it and design it to what they're looking for, not today, but also in the future, such as pulling it up to the curbsides or close to the street, get the parking pretty much out of sight and on the rear of the property. And by doing that, we reduced the number of units to get the parking out of sight, out of mind per se. And by doing that, it created the corner abutment that we are seeking for the hardship by going with the future development plans that Metro's implementing. And so by doing that, that is that one corner, as you'll see, unit number 1. So we're asking for the variance on. Everything else we met the requirements on. We also worked with the local councilwoman in the area, and she actually is supporting this 100%. So did Metro Public Works and the Planning Commission and staff. And now this is where we are. So.
Could you spell your last name for the record? I'm sorry.
McGinn.
Thank you. So all your required parking, after you take the on-street parking, is all internal. And the 1 unit that requires the setback variance, is there any chance that it could work on the other side, say under unit that's number 20? Or, I mean, I'm not saying move it. Is there a reason that it's there on the street versus the other side? I mean, you'd still have the setback issue, but I'm just curious.
The only reason that I could see visually would be up on the street, the aesthetic of the street versus a dumpster going up on the front.
Okay. Thank you.
So what is your actual hardship?
Special exception.
But it's also,
Oh, the variance.
Yeah, that was
the rear setback, okay.
Yeah, I don't, the street setback, I don't really have an issue with. And it says sky plane. Is there a sky plane issue? It says sky plane on our...
It relates to the height next to the curb. Joey will talk about sky
Is there a
plane.
sky plane issue here?
Well, whenever you break the setback plane, you're also breaking the sky plane. They're not violating the height. Were this the setback, they are within the height. But anytime you encroach into the setback, you also.
Yeah, and that I don't have an issue really with the street setback or the sky plane. I really do want to understand the hardship for the variance, because I think it feels like it's dictated by, wanting to have 1,150 square foot houses. I just don't know what it doesn't look like a narrow lot. It doesn't look like there are physical conditions on the lot, at least on the surface. So I really want to understand what the hardship is for that unit number one.
I guess that would be, based on the location and type of development, in the area, and the desire from, like I said, that we were encouraged at the beginning of the design process to move that forward, so that takes out parking in that area where the buildings are. That's not desired, so just creating the best design on the lot, the lot that we have in front of us, I guess.
What is the variance on the setback? How much?
10 feet versus 20 required.
20 is required, so we're 10 foot over.
Yes, right in this area here.
I think if obviously he didn't have the rear setback, those buildings would have to be pushed forward, and then the parking would be kind of at an issue. It looks like it's already tight parking for those units.
Yeah, I guess I'm not
either that or drop a unit like on the other side, which would reduce the parking requirement. But
actually, mathematically, I think it still ends up being the same parking, because it's still the number of units times 1.5, and then you do the math. I don't think it really changes the math, unfortunately. But that would be an obvious solution, is to cut the unit. We are stuck with the. We do have to have a stated hardship, but we have to find one.
Here's my question. Here's my question on the hardship. Now, you all have been very delicate to mention that it was recommended to you how this needed to be developed, particularly with where you had to put the parking in order to conform with what I believe one of our government agencies probably convinced you ought to be done. So I guess I'm saying, in some respects, you had some tight constraints as to what you could do with this property. Is that a hardship? I don't know. But in some respects, I do understand from a development standpoint, if you've been required to meet certain conditions from a planning standpoint. Because they didn't necessarily have to go in the back, but you're trying to please the aesthetics. Is that correct?
Correct.
Is that a hardship? You can debate that later, I guess.
I personally don't see that as a hardship. I see that as a challenge, and I think that challenge could have been met by either one less unit or slightly different design. There's several ways to answer that without.
That's what I'm asking. Is it a hardship?
I don't see it as a hardship, and I like the complex too, and the entire thing. But
me too.
I appreciate. May I say something?
I'm bound by my obligation to respond to positive vote for a hardship reason, and I'm looking for that as well.
So, I'm not proposing a design change, but it amounts to 20 inches in each of those units would resolve that issue. And do we get to vote on these separately or together? Or do we have to?
You can break them up separate.
So I'm okay with the sky plane issues. I just think that.
I believe that the applicant had something to say.
By designing it this way, we eliminate any curb cuts on any of the other streets to bring the parking in the rear. Now, they could have redesigned everything curb cuts on the side, put the parking on the front, which there's nothing actually objecting that. And then the parking would be all front and all the units would be tightened up and brought in almost as in a square. But that's not what the neighborhood nor planning or anybody else is looking for. And so by doing it this way, we felt like the hardship was by not going that direction, the direction of developing what the codes had in place at the moment.
And I agree with you. I live in the neighborhood. I'm in the Dragon Park area a lot. As you know, the Martin Center across the street is full a lot, and parking is an issue. And I think if you had parking kind of on the street, a lot of our teachers might be taking those spaces, and your unit people may not. And so I think the way you've designed this kind of enclosed in this little area is obvious that this is your parking and not just kind of neighborhood or from the center. So I think that is a factor in this.
It's a huge factor for the mere fact that we didn't want to. I live not far from the area, and I've been here all my life, so I know what the parking is like in that area. And if you do have parking out front, you can look at other developments. It's not the residents parking there. Yep. It's the individuals that are working in close by proximity.
And there are meters on Ackland now, and I know that Ackland has got a bustling restaurant kind of business too as well. And I know you got the support of your council person in the neighborhood, which that's a tough neighborhood to get support for development, so that carries a lot of weight with me.
Well, thank you very much, and we're trying to design it versus, yes, we did have to ask for the setback on that one corner, and we did that working with the local communities and the local facilities here in Nashville. And yes, we knew that we were going to have to ask for one of them, and that's what we're asking for, versus bring it all in, tuck it in like a square box, which you could do very easily and not even be talking to the neighbors. You could pull permits tomorrow. But I'm not that type. We went directly with the neighbors. Look, this is what we have. What can we do? And that's how we came about the design.
Yeah, looking at this a little bit more, and again, I'm really trying to do, and I'm sorry that you had to sit through the rest of the meeting to be last on the agenda for us to talk about it, but I really do like to understand what the hardship is, but I also am thinking about it a little bit differently, looking at it again on the 24th Avenue side. I know Joey had said that you have to choose a front, and you chose Ackland as the front, but really 24th could be the front as well. And I think that if there was an argument for having number one, it would be that it really kind of completes that facade of the property. I'm still not sure I know exactly what the hardship is, other than there are two fronts it's a corner lot. There are two fronts to the property, and you have to choose one.
So, David,
but I do appreciate that it could be there.
Very much not unlike the last case. If you read the physical characteristics of the property, would it not fall under other extraordinary and exceptional conditions, such as a property would result in peculiar and exceptional practical difficulties?
I would think so.
Thank you. This is vastly different from the other case in that other case was a condition that's already completed, misunderstood. This is to be built, right? This is new proposed. So
I think there's some practical conditions of that particular. There's some practical conditions of that particular property that do provide a hardship from being pushed in two different directions of what is really required of the neighborhood, and also the way that the neighborhood has been developed since the walkability areas, pedestrian nature of the neighborhood and the desires of the neighborhood.
And there is also a Ronald McDonald House down the street, which we like, and we're very happy that's here because it's near the hospitals, but a lot of the people are here in town to see sick family members. They may not know the kind of parking areas, or that's your building or not. I mean, to me, it makes sense the way that you have designed this, and if you were to kind of push the building in and have parking around it, I think you'd have a hard time policing that parking lot.
It would be detrimental, because I know what the parking is like there. There's plenty of parking at night, but during the day it's hard to find any parking.
Well, I agree with that, but that's really not the issue here. I mean, that's not the problem.
It becomes a hardship on the property if basically because of the neighborhood, the parking is not available for the owners because there's this Martin Center over there and there's this Ronald McDonald House.
But my point is, the only thing that is in violation here is the depth of that length of building along that one side. It's about 10 feet. Now, there are solutions to that, either drop a unit or shorten those units to meet the 10 feet. Other than that, I don't see the hardship. That's strictly a design.
The hardship is created by working with the neighbors on a design that would fit the neighborhood. And that's what we're trying to do, is to encompass the neighborhood, not decrease the neighborhood. We could, you are correct, we could reduce that one unit. No, we could actually, you are correct, we could reduce that unit. We could actually add 2 more units and reduce it all in the middle and park all around the structure and not even have that condition. But I went to the councilwoman and working with the local development group here and the architects and the engineers, and we came up with, yes, it's a hardship on me to develop it, and yes, it's a hardship on everybody else to do what I'm trying to do. It's not a hardship to go the other route. But to do it aesthetically, to improve the neighborhood, that's my hardship, is to put a nice product in there versus to put 2 more units in there, tighten them up, and to build a cube building, which you're all familiar with. And then the parking is not an issue, but it is all pretty much becomes public parking. It's private parking, but public parking.
I understand that.
So Joey, could you explain, I know they have to pick which is the front street, and what are hypothetically, if Ackland were the front, Ackland is the front. Which should they choose as the front?
Ackland.
And so we're dealing with a side yard setback, or is it because it's an alley?
On 24th now,
the short question is there any relief in changing which is the front street? Does that make it easier for us to, or get us out of finding a hardship?
Well, if you declare 24th as the front, they conform with the setback because the alley is just a property line, and then there's only a 5-foot setback required along a property line, which is the property to the I'm sorry, I don't have this on for you. Let me turn on.
But if the back were opposite 24th,
yes,
they would still need a.
You need a variance in that location.
Okay.
Yes, because you would be then 20 feet would be required there.
Okay.
And just looking at dimensions, and Brian, you may be able to tell looking in there. I don't have my scale with me, but it appears to be a wash either way you go, as far as the distance required there.
Oh, it's nearly square, yes, the lot.
We offer the same variance.
Yes.
I was looking. Yeah, I guess I was just wondering if there was a way to get out of the variance part, but apparently not. Is there opposition to this? No opposition?
Is there anybody else that wants to speak out and
would like to say something?
Well, please come forward.
Is this an opposition or?
Well, no, but I'm the Jerry Edwards, 21.
Well, hang on a second.
All right.
Yeah.
Your question was, if you declared this front, I couldn't get this picture up for you. The variance here is the same as what it would be here. So.
That's what
Okay.
Go ahead and introduce.
Yes, Jerry Edwards.
Please press the button.
I'm sorry. Jerry Edwards, 2139 Ackland Place condos, Unit F. I'm the only owner-occupied property directly adjacent to the east side of this development. The only owner-occupied. There are 5 units that will abut the east side of the development, 5 condos. All of the other 4 are rented to Vanderbilt students.
Are you in support of this?
Well, yes, in many ways, but I'm just wondering, parking is the issue. That's the big issue. And I have to police our lot that is next door. I have to police it.
Because of Dragon Park, the Martin Center?
No, the Dragon Park has nothing to do with it. Martin Educational will park there. Workers at Vanderbilt, construction guys at Vanderbilt will park back there. I had to hire a towing service to put up signs, but you have to catch people first.
Well, do you like the design of this? I mean, is this?
Well, I have no problems with the design. I mean, I've owned my unit for 12 years, and I knew at some point the owner or family member, Ms. Ferguson, probably would do something with the property. I've enjoyed all the trees that are adjacent to my condo, but know full well what goes on in the neighborhood with traffic and properties that are there. And I knew eventually, if I lived there long enough, that park setting behind me would not exist, and I understand. And the designs are all that I have seen. The pictures are very nice looking. Yes, I guess the parking is the problem. Of course, I wanted to know how much space would be between my building and the building that will be adjacent to it. That's my greatest concern because I live there and own the unit.
Okay, I don't think there's any disagreement at all about the necessity for the parking. I'm asking for somebody to give me, in good conscience, a reason to grant a variance, and so far I've not seen one. So that's all I'm asking.
The variance, I don't know which number actually you would be looking for the variance, but I do know the hardship would come back into the parking by going with the design pattern, what not only the neighborhood, the council members, and the planning commission are seeking and would like for us to implement. By doing that, we're pulling it forward. We're trying to keep the parking in the interior design. We could actually move the units back in and redesign the cube, and we would not be seeking a variance. You are correct, but it's not what the neighborhood's looking for. So I don't know how you'd put a number on that, but we're trying to do what the neighborhood's looking for and what Metro's looking for.
I guess what I'm kind of struggling with, and this may be part of the discussion, is it a property hardship or is it a neighborhood hardship? And it may meet a neighborhood hardship concept, but the specific property, therefore, maybe it may.
Location, sure.
Yeah, I mean, it clearly is in the neighborhood's interest and. The expression of the council person. But anyway, I'm struggling with the same issue to try to define the hardship, although as I think about it, as I see it, as I look at it on 24th, I'm not sure. I don't really have an objection to the aesthetic. I think it's probably appropriate to have that unit number 1 there. But you're asking for a variance which requires a hardship. So I'm trying to figure out what would that be and define it. And so we may get there, but I'm still working on it.
We've heard from the applicant and in this neighbor that parking is a big issue. And I think this unit in question, Unit 1, shields the parking lot from the Martin Center and people not really kind of looking and saying, oh, I could just park over there and go to my teacher training over there. I think that's a big issue. I really do.
Anything further to add? I'm still looking myself.
I know I don't know the exact number, how to define it with number. I do know by working with the local councilwoman, the local planning commission, local designers, we're trying to design it the best to shield the parking, keep the parking out of sight, out of mind, and protect it. But as far as the number you're looking for, I'm not exactly sure, but I know we've worked from the start of this process all the way through today.
And I can appreciate your efforts. And I just misspoke a minute ago. I said variance, and I was looking for hardship is the word I meant to use. But
And the hardship, it falls under the parking hardship that is created by moving the units forward and creating it for today's design.
I think it clearly falls under peculiar and exceptional practical difficulties. I mean,
It does.
that's a hardship.
Let's discuss that.
With this number of units, it might.
Anything else to add?
I wanted to make sure that I see one other gentleman in the audience, and that, did you have anything to say on the case?
No.
You don't have to. I just wanted to.
No, I'm the broker representing the trust that's selling this property to Mr. McGinn. And if I might, Tom McBeal.
If you take one of the seats, just get your name on the record.
Tom McNeil. And I would just like to say that from the get-go, Kevin and his people back here have gone to every possible resource to learn about what is appropriate for the community. And they have designed and developed something that is appropriate. It is not something that maximizes the number of units for him, and he has given up units to do this. And Mr. King, I know you're looking for that definition of hardship. I think that's it. He has given up for the direct benefit of the community, the people that live there and drive by it, and the people that understand the parking issue, which you do.
I certainly do.
And as far as I'm concerned, this may be the only guy sitting in the applicant's chair today that has done everything he could for the betterment of the community, and I think he deserves that variance. I think you're right, Mr. Ewing, that space shields the parking. It avoids the dumpster being seen directly, and I think it does offer some advantage to the residents being able to park there and not being forced on the street. Another issue that Mr. McGinn briefly touched upon, if he were to bring those to the center and gain 2 additional units, he'd have 2 additional curb cuts, not alley access, which eats up parking spaces. So I just think this applicant deserves your consideration for all the effort he's put into this, and for the fact that he's not trying to maximize the density that he could have on the property.
believe me, sir, that's not even a question in my mind. So.
I appreciate that, Mr. King. Thank you.
Any further discussion? Joey, on closed public hearing?
We'll close public hearing on case 83. Thank you.
You know, to me, this is a case of someone that's reached out to the neighborhood and done their homework. And one of the things that I also look at when we do these cases is, you know, this is Hillsborough Village. This is a tough crowd. I live over there. There's no opposition. Councilperson enthusiastically said, I'm in support of this. We're talking about 1 unit. We're not talking about 10 units. We're not talking about 5 units. It comes down to 1 unit and a 1 rear variance. This is something reasonable, and that's the purpose of the Board of Zoning Appeals. If the code says one thing, and someone has gone through all these steps, they've set a variant, they've said they have a hardship. You may not believe their particular hardship, but they have set one out. I do. And that's why we are here, to bring some common sense and some equity to this situation based on the code, and look at the hardships and look at what they've proposed, which isn't unreasonable, which isn't out of nature for the neighborhood. And so I think we should approve this.
I think, given how we all know traffic, parking, kind of a sense of entitlement everyone has to accessing Hillsborough Village as a matter of due course, a lot of experience. I think it definitely falls within the peculiar and extraordinary circumstances that are allowed for within the hardship definition of characteristics of the property. It may not be its location. I mean, it's more location orientation than it is the exact physical characteristics of the property, but it may be a location extraordinary circumstances. So I think the fact that this has been embraced is another testament, as you said, David, that they have done everything they need to do to to satisfy everyone's needs within the community. And that's what we're here to do, is to help ease that scenario.
And once again, there are a lot of people that live within a half a mile or even a fourth a mile of this property. There is no opposition to this, none, as proposed. Well, I would like to move that we approve this, meeting the requirements of 1743-70, and the hardship is the, exceptional practical difficulties of this particular property and the parking issues as it relates to this last unit, that this last unit shields the parking inside, and parking is a huge issue in this area, and also the hardships of shielding the dumpster from a very residential neighborhood, and also a neighborhood that has a teacher center, a public park, and a Ronald McDonald House too as well.
You heard the motion. The second?
Second.
Any further discussion?
What about the street setback? Are we going to do this two separate motions?
Yeah, we should do this in two separate. This should be the exception and the variance, correct, Joy?
Do you need two separate motions?
It'd be one motion to cover.
I was just assuming that David was not making the street back.
Okay, well, I'll add the street setback to this one.
So you want it as one motion?
Yes. Okay. Mercedes.
I'll second.
Further discussion. All in favor of the motion, say aye.
Aye.
Opposed?
No.
I'm going to abstain.
Motion carries on a vote of 4, 1, and 1 abstention. All right, members, one other item on the board's agenda today, and let me come before you.
All right. And then what we'll do is we move forward.
I just wanted to apologize to Mr. McGinn. I asked him to spell his name and not realizing that it was his name that was on the appeal. I'm sorry about that. So many words.
Procedural guide.
So many words I've been reading today.
Now, what's the point of abstaining, just out of curiosity in your mind?
Our meeting is not adjourned yet.
That's right. We still have additional business to discuss. Some of you all were not here at the last meeting, and that's fine. I put on our agenda, and probably will the next two agendas dealing with our rules of procedure. We need to update them, whether we make substantive changes to them or not. We recorded those in 2008. Excuse me. Sorry about that. The acoustics in this room are excellent, and voices carry really good. So I believe we're second to the skirmer horn on our acoustics.
And the Ryman's first, skirmer horn second.
I'm sorry. I stand corrected. I've never been to the Ryman. So, but
close second.
We last adopted our rules with major changes in 2008, and so we're due to refresh these and update them. I have got a list that I will submit to you all of changes that I see that need to be made. They are, for the most part, and I'll give you a good example, our meeting location is still listed on Murfreesboro Pike. Okay, this is pre this room getting constructed, so we need to update some of those things. I also asked at that time if you have any proposed changes you'd like to make, get those to me. I believe I had a telephone conversation.
Your time's up.
My time is up.
I'm sorry, Mr. Hargis. We'll take that under consideration.
But there we are. But if there's anything, and now we're on the record, are there any changes that you are proposing? If so, between Ms. Huey and I, we're going to try to.
Aren't we having a separate meeting to discuss all this, Joey?
Do we get time to review this first?
Yes. I mean, everyone should just go and read their Metro Code and bring back any suggestions, and there will be an advertised meeting that we get together and discuss any recommendations we have.
I wanted to make sure if you had any today, I'd take notes of them. Process-wise, you all need to communicate with me directly. No group emails. Please send those to me. Those will be kept in our office. Any proposed changes, what I'll do, I'll take the document, provide you each a copy with my proposed changes labeled out, and then proposed changes of the board members who's proposing them. It's not a problem. At our next meeting, I need to have those really soon. Our next meeting is September the 6th. I need to have those probably by the end of next week.
Well, let's schedule a date and advertise this, and if anyone has any changes, they'll email you directly.
Yeah, September 6th, I'll put it on our agenda. We haven't published that. We just closed it yesterday. So we will put a discussion of proposed changes to the rules, but I need those 10 days prior.
Okay.
So that way I can give to you, here are all the proposed changes that you're proposed, and then discussion can occur. So long as there are no additional changes, we can vote and adopt amended rules at that hearing, but I have to give 10 days notice.
And we will do this in conjunction with Metro Legal, who will tell us if other proposed rules changes are legal.
So
and
sooner you getting them to me is better. I can work with John Michael to say, do these look fine? Do these meet the code? Are there any pitfalls? But I just reminding you, we need to get those really soon. And
I do have one question for you.
Yeah,
I had made a note on this a long time ago under number 5, item C. I had made a note to reword that because it appears to contradict itself, I think, but I don't know if you could think about that. It says that, that anybody can refile, but we can say, no, you can't refile if we don't feel like they're making their case.
This would be an example. Decisions made to this rule are appealable to you. Now, we have in instances in the past had multiple appeals to you for the exact same, like multiple rehearing requests over and over for the same substantive matter that you've already ruled on. And you have in the past just basically the second question of this rule, disallow any future filings on that same point of order. So
we had a version of double jeopardy.
Yeah, we've had a rehearing request, and here was their position. Yeah, here was their position for the rehearing request, and you rejected it. And that's basically saying, then the second time we had the same, bring another rehearing request for the identical items, and you rejected it and said, all right, that's enough.
But this is saying it's the same appellant and property, or the same appeal by other parties and other properties?
It could be handled both ways. You all have, as the first part, that discretion is yours. It could be multiple parties bringing the same rehearing request.
Like we could say, in the days before the chicken rule had been finally resolved, we could say, we've made a decision on chickens, stop asking us about chickens.
Well, if it were the exact same property, if the same owner we had turned down came back the next meeting and said, I want chickens, and then we said no.
Yeah, this board used to have a rule in it prior to this one that was a reconsideration. That was essentially, I don't think you got it right. Would you please reconsider? And we stripped that because you made a decision. Not, I'm saying you as a board.
When they have an appeal.
This board made a decision. They have the ability to appeal or request a rehearing. So the ability to come in here and say, would you please reconsider, was redundant. So that the board chose at that time in 2008.
And Mr. Hargis, I would note as counsel to the board that a number of other boards have adopted the striking down of what had once been longstanding reconsideration motions and do not hear reconsiderations anymore. So you're in good company in that regard.
But isn't there an answer to that? I mean, if they have additional evidence or something that was
they can ask this board for a rehearing with new evidence, right? And that's in your rules. Or they can sue the board into Chancery or Circuit Court. That's their other option. But
they have other remedies.
So
they do have other remedies.
We'll meet. Just let us know when. And
it'll be at the next regularly scheduled meeting is when this will be on the agenda. Yes, I'm gonna make a couple changes and send you documents individually. Again, emails will come one-on-one. No group emails, please. And any changes that you have proposed, if you'll send them to me. John, or Linda, 10 days out from September 6th? No, coming back. Anybody got their iPad with them or something? 10 days prior to the, it'll be the 31st of August. So yeah, if you can get me your proposed changes by 25th, preferably, if you can get those. I know it's a Saturday, but a week from tomorrow, that would be helpful. I think that's plenty of time. And then what I'll do is I'll incorporate those proposed changes in here. We'll discuss them. If you're okay with them, fine. If not, we'll hold on a little bit.
Before we adjourn, I want to
thank you.
Change my vote on that last case from an abstain to a no vote for the record.
You can't do that. But once the vote is cast and there's a decision either way, those votes are stuck. So if you get 4 votes, 4 to deny, 4 to grant, then the folks that have voted, they're there.
If, for example, if it were a 3-3,
Now, if we had
you
a
could have
tied
changed your
vote.
vote, but if it goes up or down one way, it's,
Yes.
that's it.
I thought these rules said something to the fact that you can change a vote up to 30 days after, or whatever that is. Clarify that for me, Mr.
I haven't seen the rules in a long time, so I just need to go back over and remember.
Maybe something for our change of rules.
Yeah. Let's review all that and put them on the table.
I do not say it, Mr. Vice Chairman, in your rules. It does say that you have to have 4 concurring votes to grant or deny an application. It does say in the event that 5 or more members are present, failure to receive 4 votes within 30 days shall be deemed a denial.
John Michael, do you have any take? Okay. I think the only time you could change your vote, my understanding, I don't remember looking at the code, is if there is not a 4 vote to either approve or disapprove, then we're looking for people to change their vote. If we ask if somebody wants to kind of break the tie, if you will. No.
Yeah, I don't see that either. So, for us, once 4 votes has occurred either way, that case is disposed of. Then, now, obviously, there's the possibility of the appellant or an aggrieved property owner, not a board member, could request a rehearing. Because board members do not have a stake in the case, so that request for rehearing can't come from you. Now, if there's a complaint that you've approved something and you knew that you set conditions and they're out there blatantly violating those conditions, that's an enforcement matter through our department that we can handle. We can drag them back here by means of a show cause hearing.
So those watchers of Channel 3, they see Diane Neighbor say, the votes are open, and then does anyone wish to change their vote? The vote's closed, tally the votes, and
It's over.
That's it.
We do. That's all, guys. That's all I have for you. All right. Thank you. With that, the Board of Zoning Appeals is adjourned. Thank you.